the recording. Okay, welcome everyone. This is our first training on our new Zoom platform. So hopefully everyone likes it. Hopefully it was a little bit easier to get into than we have with WebEx. I'd like to welcome everyone today to our FOIA for ANC training, and it's being presented by the Office of Open Government. So Director Nikhil Allen is here to lead us through this about a little over an hour and time on this presentation, and then we will open it up for questions. So if everyone can just mute themselves for right now, that would be fantastic. And then, like I said, we'll have plenty of time for questions. I'd like to introduce myself first before I get into Nikhil's very elaborate and worthwhile bio. But I'm Gail Fast, program analyst here at the Office of the Advisory Neighborhood Commission. And I am joined today by many of my colleagues. Many of you know Kathy Williams is on the call, Denise Wichter, our new general counsel, Andrew Gerst, who is our attorney advisor, sort of working on land use stuff, and Amber Wright, our administrative assistant. So you've got the whole team here today to go through the training. So without further ado, let me just tell you a little bit about our presenter today. Director Nikhil Allen is an experienced government attorney and executive with a reputation for good governance and finding innovative solutions to complex issues. She was named by the District of Columbia Board of Ethics and Government Accountability on July 9th, 2018, and reappointed on January 2nd, 2023, to serve as the Director of Open Government. Director Allen is an advocate for transparency in government and is respected and a dynamic public speaker and presenter. Director Allen has solidified the Office of Open Government's position as a strong resource for information and guidance on open government issues. So we are very excited to have her today, very talented. And so I'm going to turn it over to Director Allen. I'm going to go on mute as well.
Thank you so much. And thank you, commissioners, for being here and for taking this training on the DC Freedom of Information Act for ANC commissioners. We present this training in conjunction with the Office of Advisory Neighborhood Commissioners, and I would like to thank all of them for welcoming me to be here to present to you today. So let's get started. Okay, our agenda is as follows. I am going to begin with a brief recitation of my office and what we do, and then we'll move on to DC FOIA law, the basics. Then we're going to discuss records subject to DC FOIA. We'll then discuss responding to DC FOIA requests, and I will end with questions and answers. If you do have questions during the course of the presentation, it is fine with me, commissioners, if you unmute yourself and ask the question and I can stop, or if you'd like to hold your questions until the end, that's fine too. Okay, let's get started. The Board of Ethics and Government Accountability, of which I'm a part, advises the district government on FOIA. Our board issues a best practices report that recommends changes to FOIA law. My office, the Office of Open Government, is an office within BEGA. We can issue advisory opinions on FOIA issues, which we call the implementation of FOIA by statute. We also serve as an advocate to ensure the FOIA process is fair and executed properly in the District of Columbia. Now, my office is particularly responsible for training public bodies on the requirement of FOIA. And as I mentioned before, our office and the Office of ANCs are required to train ANC commissioners on DC FOIA twice annually. So let's start with the DC FOIA laws. ANCs should be familiar with DC FOIA and its implications on their roles as public officials. DC FOIA is the law that gives the public the right to access government records and information. The law is designed to promote transparency and accountability in government. So most of us are familiar with FOIA. We, as government officials, receive FOIA requests, but as commissioners, you also may put out FOIA requests to DC government agencies. I don't specifically address that in this presentation, but if you have questions about submitting a FOIA request, please let me know. And our office is also available to assist with the submission of FOIA requests. Now, DC FOIA applies to all public bodies, which includes the mayor, DC government agencies, including independent agencies like Vega and the DC Council. ANCs are covered under this provision. Now, here is an overview of the FOIA law and how it came to be. So DC public policy entitles all persons to full and complete information regarding the affairs of government and the official acts of those who represent them. That is the district's public policy as it regards FOIA. The actual law was enacted in 1973, and it was, quote, designed to pierce the veil of administrative secrecy and to open agency action to the light of public scrutiny. So the reasoning for that is to make sure the public is informed, because we view an informed public as able to better talk to their public officials, make selections about who we are, and to make government function properly. Now, the FOIA Act gives any person the right to request records in any form that are prepared, owned, and used in the possession of and retained by the public body or the government. When FOIA requests are submitted, advisory neighborhood commissions are required to make a reasonable search for those records. And on an annual basis, DC government agencies are required to report FOIA disclosure activities for the previous fiscal year to the Secretary of the District of Columbia, the DC Council. So that report was just released on March 1st. Now, there are FOIA regulations that apply to agencies under the mayor's authority, and also the Office of the Attorney General has established its own FOIA rules. They're listed here. They're 1 DCMR Section 400 and 1 DCMR Section 1300. ANCs may elect to adhere to these regulations in the administration of FOIA. Those regulations can be accessed online at the links here, which is www.dcregs.dc.gov. I also put another link to casetext.com, which is sometimes easier to use than dcregs.dc.gov. So again, I emphasize a public policy, and let me read it again. And I'm emphasizing this so that we can just keep in mind the need to be open. So the second provision that I did not read before is that FOIA provisions, the provision of the subchapter, shall be construed with the view towards expansion of public access and the minimization of costs and time delays to persons requesting information. So this provision is basically said that any restriction that we put on releasing records will be construed narrowly by the courts if there's an appeal. So it's better to err on the side of openness and providing a record. Although I will get into FOIA exemptions a little bit, and those also apply to records when you're considering what to release. But again, those are construed narrowly. And DC FOIA management, and there's a central body within DC government that handles FOIA requests. Instead, each DC agency and each ANC commission processes its own records. And that makes sense for us because we are such a large government and so different in the types of records that we maintain. And we understand our own systems. So if someone is coming to a records to find a record, it's better to contact us directly than to go to some central body. The primary contact for DC FOIA is the ANC Commission. The Office of ANCs may also assist ANC commissioners with DC FOIA processing. The DC Mayor's Office of Legal Counsel handles FOIA administrative appeals, and the Office of Attorney General handles FOIA litigation through its Civil Litigation Division. It also provides ANCs with advice through its Legal Counsel Division. So here are the basics. A DC FOIA requires ANC's disclosure of public records unless there's exempt from disclosure. Some types of information are exempt, such as personal privacy information, law enforcement records, trade secrets, and attorney-client privilege information. Members of the public, including ANC commissioners, may submit a DC FOIA request to obtain specific records or information held by DC government agencies. Now, DC FOIA also requires that agencies and ANCs proactively release certain information without a FOIA request. So that type of information includes employee records. It includes final administrative decisions, the contact information for our FOIA officers, and similar types of information. DC law requires that the information should be available upon request and should be accessible online. Also, there is a website, opendata.dc.gov, that's maintained by the Office of the Chief Technology Officer, where DC government agencies proactively release information. So some of the information that might be sought from you via FOIA request, you could send a requester to opendata.dc.gov, and that information may be there.
Okay, one question.
Yes.
On the employee information that you have to release, that's only, employee records are only to the employee or an authorized agency.
That's correct. So the ones, let me be very specific, the ones that need to be released without a FOIA request are employee salary information. And that information is actually on DCHR's website. So that's usually taken care of for you. It's a large database. And I think now they have an electronic database where they list the employee's name, title, and salary. All right, moving on to what records are subject to DC FOIA. Oh, I went backwards, sorry. Any document possessed by a public body is a public record. So any record pertaining to the Advisory Neighborhood Commissioner's conduct of government business may be requested under FOIA. And it covers more than paper documents. It covers electronically stored information, which could be audio, video recordings, photos, or other electronic information. So here is the statutory definition of a public record. It includes all books, papers, maps, photographs, cards, tapes, recordings, vote data, including ballot definition material, raw data and ballot images, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used in the possession of, or retained by a public body. And this also includes public record information stored in an electronic format. So email and text messages are subject to DC FOIA. If you're conducting ANC business through a personal email account, your Gmail, Hotmail, or Yahoo account, for example, or a personal device, your Apple phone, Android phone, then ANC-related communications are still subject to FOIA, regardless of whether they're generated on private equipment or on personal accounts. So keep that in mind. I always advise to try to segregate that information from your personal information on your phone or other devices. So text messages are subject to DC FOIA. In March of 2022, my office issued an advisory opinion on the applicability of FOIA to text messages. We stated the breadth of the statute and the interpretations given by the Federal Freedom of Information Act and our sister jurisdictions to comparable statutes support the conclusion that text messages, to the extent that their contents are government business, are public records. So if someone asks for a text message from your phone as part of a FOIA request, that's a record that you should have to produce.
I have a question.
Yes.
Thank you. How is it like requested? So I text message from a Google Voice number. And so the assumption is if I got a FOIA request from a text message, would I produce, like, am I screenshotting this information and sending it and emailing it? Is the assumption that I didn't delete it from my phone? Are there like any consequences to that?
Yes, there is a assumption that that you are retaining it according to the records retention schedule of the district. If you don't have your own records retention schedule. So we would not expect that you deleted that message if it was related to the ANC. Now,
Gotcha.
production is kind of another question. There is some case law that just came out that said there's no obligation to create a screenshot because that's creating a new record. That's a recent case that just came out. So for the how of producing it, you could do that. There's no requirement that you screenshot, but that's one way you could do that. Or email it to your @dc.gov email account, which I'll talk about now. That's another way to produce the record. And it's really one way if you're using other electronic records, if you're able to copy that dc.gov email for your ANCs, then the government already has a record of it. So it may be easier on you in the long run. So
Okay.
getting to that, as a best practice, we do strongly urge you to use that dc.gov email for ANC business. And again, DC government retains those records in its servers and virtual servers. So the information will be there. So if you ask for it via FOIA, it will be easier to produce the records through the system. So we advise you to conduct your business on that account. If you're using a different email account, copy that @dc.gov account on your ANC correspondence. Again, I will impress that if a requester asks for emails and they happen to be on your private email account, you'll still have to produce them in conjunction with the FOIA request. So the advice here is to make sure that a DC government operated account has that information so that's retained, or be prepared to release information that might be on your private account. And the Office of ANCs, as well as Office of Attorney General and others, are available to assist with the process should you receive a FOIA request that implicates any of these mediums where your information is being stored. So next, I'll move on to how to respond to DC FOIA requests. So I've covered kind of the obligation to retain records, and that's going to vary for each ANC. I know each commissioner, how you do business is different, but the next part of this training will help you in thinking about how you release this information. So here's the DC FOIA process in a nutshell, and kind of there are 5 steps to it. The first is the receipt of the FOIA request. We're going to talk about that and what the form is there. The next step is processing the request. So you're going to look to log it internally, create some type of file, estimate fees, send in acknowledgement letters. Step 3 would be retrieving the records. So you're going to conduct a search for responsive records request records from others if that's necessary, and review those records. The next step is to make redactions, which I'll talk a little bit about if that's necessary, and apply exemptions and calculate your final fees. And the last step in the process is you approve the release of records or deny them. So there will be a response letter that has any fees or fee waiver in that letter, and then a determination to release the record. So let's start with records requests. So who may request a record? Pretty much anybody can request a record. We don't restrict that in the District of Columbia. So the statute reads, any person has a right to inspect and at their discretion to copy any public record of a public body except as provided in the DC FOIA exceptions. And that's in DC Official Code Section 2-532A. The form of a request for a record of an ANC may be made orally or in writing and must be directed to a particular, it says agency, should be ANC. The requester may be asked to submit in writing their request. So if you receive an oral FOIA request, you can ask that person to put it in writing, to send you an email, send you a letter, send one to the commission. And requests can be received by any form. The DCMR right now says mail, fax, or email, but of course you might receive them via text. You could receive them in multiple forms, but you are able to ask that requester to reduce it to whatever format you're most comfortable with receiving. So here is the ANC's responsibility for processing requests. Individual commissioners are responsible for tracking, managing, and responding to FOIA requests for records in their organization's possession and control, and administering their organization's FOIA program. So you as a commissioner, it's your responsibility, and the commission that you're a member of has that responsibility as well. The ANC commissioner that is the subject of the FOIA request, with the assistance of the Office of ANCs, must conduct or coordinate a reasonable search for records and respond timely to FOIA requests. The Office of the Attorney General also is able to provide you with assistance. As you all know, OAG is charged by statute with providing ANCs with advice in regard to DC FOIA, other statutes, and issues concerning ANCs. The Legal Counsel Division of the Office of the Attorney General usually provides this guidance, and you can receive guidance from the Office of the Attorney General by emailing oag.anc@dc.gov. They also post advice letters on their website. Some of them deal with FOIA. And the link for that is here. And it's a good resource for researching issues that you may have that related to FOIA or any other issues. Now, the first step, as I mentioned before, when an ANC commissioner or an ANC receives a FOIA request, they should acknowledge the receipt of the request via email or other initial communication to the FOIA requester. I don't believe that any commissioners are using the FOIA portal to my knowledge, but there is a FOIA portal. If you're interested in that, if you have the budget for that, I believe you can contact the Office of the Chief Technology Officer to be included to get a license for the FOIA portal. But DC agencies use that system to process FOIA requests. And
currently, we're not part of the FOIA portal, and I was just corresponding with the gentleman in charge of the FOIA portal.
Yes.
And the problem we're having is telling, well, first we're part of the legislature, and it's the mayor's FOIA portal, but the second is we're having difficulty getting the comprehend. There's 46 different ANCs. They only want to list our office.
I understand.
So I don't think it's an option right now.
Thank you for that clarification. But if you want to submit a FOIA request as an ANC, you may submit one using the FOIA portal. So that is another way to access agency's records if you would like to submit one to an agency yourself. But thank you for clarifying that ANC are not users, so to speak, don't have licenses to process through, it's called FOIA Express now, the FOIA portal. All right, so more on responding to FOIA requests. So the initial correspondence should include your letter where you're introducing yourself and acknowledging the request. And if you have any clarifying questions, I think that's important to put in this first response to them. If you don't have clarity as to what a requester is seeking, you should definitely either reach out to them in this first letter or subsequently to have them clarify what they're looking for. There is a time frame for responding to FOIA requests, which I'll get into in a few minutes. But if you have clarifying questions, that clock is stopped until you receive the information you need to be able to process the request. The initial letter could also include a discussion of FOIA fees if you know that, or you could just let them know that there may be fees. If there is a processing track designation, this is usually for large agencies, but it's good to assign them a number if you're receiving a lot of FOIA requests for internal tracking purposes. And make sure you provide your contact information or the FOIA officer's, sorry, my light went off, or the FOIA officer's contact information, your commission, and your signature. I think my light's just not going to come back on. Hopefully that's not too distracting. We're saving energy here in the district. General timing for responding to FOIA requests. As I said, initially, you have a specific time frame, and that clock starts when you receive the FOIA request. So for records other than body-worn camera recordings, you have 15 business days to process that request. For body-worn camera recordings, 25 business days. There are certain instances where it's only 5 calendar days, but I don't think that you all will have to worry about processing those types of requests. An ANC may invoke a 10-day extension by written notice to the requester, setting forth the reasons for the extension and the expected determination. So I'll say this at the outset, 15 business days is not a lot of time. So what I always advise is that communication with the requester, if it's the type of FOIA request that may produce a voluminous record, such as email, that you have to go through. The courts have said that we should produce them in waves, so to speak. So if you have a large voluminous email request, you would produce what you can within the 15 business days, but set a schedule with that requester for when you will release the other information. But under unusual circumstances, which I'll describe in a few minutes, you can invoke that 10-day extension. So that will give you a total of 25 business days. And again, if you're not clear about what a requester wants and you communicate with them to get clarity on the FOIA request, that stops the clock of 15 business days until you get a response from that person clarifying your question, because you should be able to identify the records without difficulty. So I always say an example is if someone lost their keys and they didn't tell you anything about them, they didn't tell you what color they were, they didn't tell you how many were on the keychain, you're not going to be able to find the keys. So a FOIA request should be detailed enough that you can find what they're actually looking for. And the law, case law, as well as the statute provides methodology for you to be able to do that. And it's reasonable for you to be able to do that. So unusual circumstances where you can invoke that 10-day extension, if it's not a body-worn camera, the need to search for, collect, and examine a voluminous amount of separate and distinct records that are demanded in a single request. So that usually emails, electronic records, anything that you have to get from someone else usually falls in this category. The need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of the public body having a substantial subject matter interest in the request. So this is an example where another commission may have information that you're looking for another commissioner. If you need to consult with them, that's reasonable to take this extension. Also, if it's another agency that's implicated or a DC government agency that's implicated, you should reach out to that agency with the request and let them know about it, but that you're able to get an extension of time to do that as well. So for body-worn cameras, you can invoke a 25-day extension if you cannot find a vendor that's able to perform redaction. So this is usually reserved for our law enforcement agencies that have officers with body-worn cameras. And that's NPD for the most part. Now, you are only required to provide existing records. I touched around this a little bit earlier when we were talking about text messages. FOIA does not require you to create documents or opinions in response to a FOIA request. And you're not even required to obtain records from another agency. If any of these apply, you can just deny the FOIA request. You don't have to answer questions that are disguised as a FOIA request. A FOIA request is a request for records. So sometimes you will see a request for information and they'll say, I'd like you to tell me about this meeting, or I'd like you to tell me about your decision here. So those types of questions are not FOIA requests because they're not asking you for any records. So you can deny the FOIA request. And whether or not you want to answer the questions or not, that's up to you, but FOIA does not require you to. Your only obligation in meeting a FOIA request is to provide access to your records. So here are some tips for responding. First, make sure you read the request carefully so that you understand what you're being asked for. And this is key. Even if it's not clear to you, then it's not a good FOIA request, and you need to make sure you contact that requester and do that as soon as possible. Determine if you have the records or if someone else in your organization may have them. Provide an estimate of cost. So you're able to assess costs for review of documents, for reproduction, and things of that nature. So if you happen to know those fees and you could assess those fees ahead of time, that's important for you to be able to do. You may receive a request from a journalist, for example, that asks for a public interest waiver. So you will have to make that determination as well, whether you want to grant that fee waiver because it's in the public interest to have the information that they're seeking. So that's something that you should also consider. So what is an adequate search? An adequate search is what you're required to do in response to the FOIA request. So it's not whether the documents exist or not, but it's whether you searched adequately. So the courts look at the appropriateness of the methods used to carry out the search, not necessarily what you were able to produce. So for example, if you know that you sent an email to someone on a particular date and you searched all of your personal emails for that, and you also went to dc.gov and was able to conduct a search for those records, and you say, hey, I didn't find anything, they didn't find anything, that would be seen as adequate, even though it did not produce any fruit, because you were taking reasonable actions to try to locate that record. So it doesn't have to be perfect. Again, it has to be adequate. So the reasonableness of your search will be looked at in light of what was actually requested. And it should be, the courts have said, reasonably calculated to uncover all relevant documents. So redactions might be necessary after you review the records. So any information that's protected under a DC FOIA exemption has to be withheld or redacted. Now you can voluntarily release it if you would like to, but DC FOIA requirements say that there are categories of documents that the government can keep private or keep from the public. And those are listed in DC Official Code section 2-534 in its entirety. So examples are documents that relates to law enforcement activities, recognized legal privileges such as attorney-client and work product privileges, documents that are required to be withheld under other laws, sort of HIPAA and FERPA are ones that you would see often, documents that reflect the internal deliberations of the government, and documents that would violate someone's privacy. So you would either redact that information or you can withhold the record in its entirety. So here are some frequently used FOIA exemptions. So as I mentioned earlier, we being the government, just released the FY23 FOIA report. And these are the 3 exemptions that were used most often. Trade secrets, 384 times. Personal privacy, 2,878 times. And the law enforcement privilege, 1,777 times. So we'll go over these next, as well as the legal privileges that I mentioned. So exemption 1 is trade secrets. So trade secrets and commercial or financial information obtained from outside the government to the extent that disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. So as a government, we do receive commercial information, could be in the form of proposals, could come in the form of contract negotiations, could be in the form of a contractor creating a record for the government. That information might be proprietary. So in that instance, you would be justified in withholding the information under exemption 1. Exemption 2 is the one that's most used, personal privacy. So that's information of a personal nature where public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. So some of the information there that you would obviously redact or not release would be like social security numbers, people's names and addresses, information that's very personal to them that we as government officials are able to collect. You would redact or withhold records in its entirety if the record itself would violate someone's personal privacy.
Where this is Denise, where we've seen this with relates to ANCs, our constituents who are writing about to you all, the frequent question is about personal issues that they're seeking help on.
And do you usually withhold the whole record, or are you just redacting part of the record?
If it's something that we're doing on behalf of an ANC, we redact the name and any identifying information that would lead somebody to know who the person was, but not the whole record.
Gotcha. So it's a good point of practice for you all to know for those constituent letters and requests. Again, we want to make sure that no one's personal information is disclosed. And you see, we use that one a lot as the government. Exemption 3, law enforcement. So this may come into play if you are receiving records from MPD or requesting them. So the law enforcement exemption 3 is investigatory records compiled for law enforcement purposes, including records of counsel investigations and investigations conducted by the Office of Police Complaints. Law enforcement records that disclose investigative techniques and procedures generally not known outside of the government or that would endanger the life or physical safety of law enforcement personnel are generally withheld. So one of these examples that I had recently was a training manual. There was a request for that information. And also they were looking to see, well, does the training manual need to be released without a FOIA request? They could withhold that record under exemption 3 because again, it would disclose their investigative techniques and procedures generally not known outside the government when that record was compiled by the police department for the police department and not released outside of the police department. Now, there are legal privileges that also apply in FOIA. So again, we are able to have private discussions that we do not have to disclose. So if you are working with an attorney work product, you could withhold a redacted document that applies to a document that's prepared by an attorney in anticipation of litigation, no matter the status or stage of the litigation. Attorney-client privilege, that exemption protects confidential communications between an attorney and client when the ANC commissioner or the ANC commission itself is the client, and when the privilege is necessary to obtain legal advice. The last and probably one that you could frequently use is deliberative process privilege. And this is the method through which an agency or an ANC creates policies, opinions, rules, and regulations. So the final document is what is the actual record. So kind of the back and forth that happens before the creation of the record can be withheld under the deliberative process privilege. So again, to qualify under this exemption, the record has to be pre-decisional and deliberative. So it's before they made a decision and there's some discussion about what to do. A document is deliberative. It is part of an ANC give and take process by which the decision itself is made. So we're looking again, just keep in mind, these are records. So they are usually emails or documents or something of that nature that's final. When you're using the deliberative process privilege, you're saying this is not the final version. FOIA fees. So an ANC may establish and collect fees not to exceed the actual cost of searching for, reviewing, redaction, or making copies of records. Records can, as I mentioned before, be furnished without charge or at a reduced charge where the commission or commissioner determines that a waiver or reduction of fee is in the public interest because furnishing the information can be seen as beneficial to the public. Any requester that's seeking a waiver has to actually request it by providing a statement in their request letter explaining how the waiver of the fees would be a benefit to the general public. That's not something that you have to come up with as an ANC, but they should be able to tell you why it's a public interest waiver. And generally, you would see that from journalists. The last step are decision letters. The ANC decision letter should contain the following information. First, whether the record that you're releasing was released in full, partially released, redacted, or withheld in full. You should include the name and the contact information of the person that made the decision concerning the release of records. That's usually the person who's writing the letter. A reference to the DC code provision that is the basis of the decision. So if it is a redacted document, you would cite the DC code provision that provides for the redaction. And lastly, you will provide a statement advising the requester of their appeal rights.
Mikhail, we have 2 questions that came in the chat, if I can
Okay.
ask them, because I think one you just covered. The question was, because it has to do with the fees. Would an ANC and/or an individual commissioner be eligible for a fee waiver for a FOIA request?
If they're making the request themselves, yes, if they can articulate how it's in the public interest that they would receive that information. Again, it's an argument that they would have, so to speak, they would have to make to the agency that is in the public's interest.
Great. And there's one other question. It said, what is the intersection of the open meetings requirement and the deliberative processes exemption?
Well, for open meetings, you have the ANCs have their own set of rules for open meetings and areas where meetings can be closed. When you have a legally closed meeting, those records that are discussed and created within the closed meeting may also be withheld under FOIA if an exemption applies. So that's kind of the intersection where the meetings come to play. The documents and records attached to the meeting record as a whole. But if it's part of the discussion that was not open to the public for a statutorily sound reason, then you should be able to attach some of these same FOIA exemptions to those records that were discussed in a properly closed meeting.
Hi, this is
Thanks.
Denise again. Can I add to that one? Because I think I know what the question is. There's very little that an ANC can do in a closed meeting. So in reality, there's very little of your deliberative processes that would be closed, except perhaps by email correspondence that might not otherwise be public. But because you're required to have any meeting where there's a quorum open to the public, you would not have too many opportunities for deliberative process. Not to say you don't, but it doesn't arise that often.
And thank you for that clarification. I hope that answers the question. Okay, I'll move on to the last, almost last slide. Appeals of FOIA decisions. A requester that receives a letter of denial or where ANC fails to supply the record within the statutory time frame, they may file an administrative appeal with the Mayor's Office of Legal Counsel or institute civil proceedings in DC Superior Court. And that is the end of my presentation. Thank you again for being here, commissioners. This is my staff and our contact information. And I will take any questions now if there are any more in the chat, or if you'd like to just come off mute and ask any questions that you have. And I will make sure to provide a copy of my presentation for you all to have later if needed.
So thanks so much, Nikhil.
Before we get off, Gail, I have a question.
Sure, go ahead.
Okay. Good afternoon to everyone. Once again, Director Allen, thank you for presenting that. I think that my colleague, Denise Wichter, mentioned it earlier. I just don't think it can be emphasized enough that right now it appears that we are not receiving FOIA requests from the portal. That is not under the Office of the Advisory Neighborhood Commissions. I believe the Office of the Mayor is working on it. They're very much aware. So if anyone requests the assistance of OANC for their FOIAs, please make sure that we receive the direct letter from you. This office is here to assist. As we all know, many of our ANCs are pretty good at FOIA, and they answer to themselves. They provide themselves as their own FOIA officer. But when you need the OANC, please make sure you let us know. And if you submit something to the portal, make sure you submit the same thing to us. Thank you, Director Allen. I appreciate that.
So I believe there's a question from Commissioner Shapiro. I know you had put some in the chat, but if you have another question, go ahead. You're on mute, Commissioner Shapiro.
Thank you. That was my question about the intersection of the Open Meetings Act and the deliberative process. And just to provide a more concrete example for clarification, let's say our ANC is talking about our policy toward a APCA licensee application and the terms of a settlement agreement. And we are emailing each other back and forth with a draft and making comments about potential components of that draft and working on something that we are willing to take forward. Are all of those emails and all of those interchanges interpreted to be deliberative, or are they interpreted to be something that would have to be revealed in a FOIA?
I would say that they could be seen as deliberative. I would have to review them. The argument could be made, since argument could be made for many things within the scenario that you gave. Also, you might be receiving trade secrets, so information that is that you can withhold on that basis, because you could harm the commercial interest of the party. So again, it's an argument to be made. So I couldn't advise you that yes, you would be successful in withholding it under the deliberative process exemption. But I think a argument could be made for it being a proper withholding of that email exchange.
Okay. And if it's withheld, and there's a recent incident with another nearby ANC in which a individual and organization sued the ANC for a decision it made, but also sued the individual commissioners. And there is apparently a lack of clarity on the obligation of DC to defend an individual commissioner in these types of actions. It wasn't a FOIA action, but it could have been a FOIA action. So is there any clarification on that?
Well, the district is representing, in that particular case, the district is representing them, and the actions that they committed were all in the course of their official duties.
But
Additionally,
it's not obligatory. There is not, it was, my understanding is that the DC did not have to defend them.
I was part of the decision. I mean, I worked with the OAG on that decision, and it never came up that they didn't have to represent them in their individual capacity. Additionally, there are some complexities with that lawsuit that they couldn't, the code section they were citing did not allow them to sue people as individuals, but only as officials. So, but each case is taken by the OAG individually. If you did things that were not in the course of your official duties as an individual, they may not represent you. It's done on a case-by-case basis. And I don't think, with FOIA, I mean, the couple of FOIA cases have gone to litigation. The district has represented the ANCs.
Okay, thank you.
Do we have any other questions? I didn't see anything else in the chat, but we're all on screen right now, so you can use the emoji. The raise your hand is always, for me, great one to use. Commissioner Prince.
Sure, thank you. Thank you for that presentation. I think interested in knowing, are there sort of time limits on retention? Are there types of records that have to be retired on a time schedule? I'm thinking, comparing to my service in federal government, where there are quite detailed rules on that sort of thing.
Yeah, there is a general retention schedule for the District of Columbia for all of its records. I am not sure. I guess the Office of ANCs can help me know if OANC has its own records retention schedule. But if not, you would follow the general DC retention schedule. And yes, depending on the records, after a certain amount of time, it should be sent to archives, or you can dispose of it properly.
If I could have a follow-up, then, is it safe to assume that anything that happens on an official DC email address is sort of retained by the system, and then when the commissioner leaves the system, they're no longer responsible? I assume when an account passes from one commissioner to the other, it must be wiped clean.
No, that's not correct. DC.gov accounts are kept in perpetuity. So
well, I guess, I'm sorry, I meant that when the next commissioner comes in, they wouldn't have the mailbox of the previous person with all their folders and files and so forth. or might they?
They could request it. I'm not sure. I think that's OANC question, but the District of Columbia government retains it. So it's there for whomever receives it.
Thank you.
Kathy,
Before we go on to Commissioner Barry, also want to, Commissioner Prince, I agree 100% with what the director said. She's correct. It's based upon the previous commissioner's request to take certain files out, especially personal files, before that ANC mailbox goes further to the next commissioner. And we have a full archive system under the archivist, as she mentioned. At any time, just let us know. We'll send you the paperwork for archiving any of your items. I'm sorry, Commissioner
That's
Barry.
good to know. Thank you.
Okay. No problem.
before we get to Commissioner Berry, I believe that Commissioner Sen had her hand up.
Okay.
I don't know if she still wants to ask her question.
No, I was trying to clap and say thank you and congratulations. Instead, I raised my hand and lowered it. Thank you
No
very much.
Okay. Commissioner Berry?
Oh, no, I just want to comment on that. So when receiving my email, I didn't have access to like any files and stuff, but definitely all the emails and responses were available, but no like saved documents or schedules, anything like that. I didn't have access to that. To answer the other person's question.
What we have done in the past, Commissioner Barry, people have requested the information. If the information was available, it was submitted, it was sent to them. In a previous administration, all ANC mailboxes had been wiped clean because your administration starts with you. Some ANCs, some persons did not retain it, and others were able to go ahead and delete it because it had some personal stuff on it. Let us know about your ANC, and we can check to see whether or not there's information prior to your coming on board. Okay?
Okay, thank you.
Okay. I don't know if there are any other questions out there. I want to thank everyone for attending. I know it was sort of an afternoon one, but we thought this was a good time. Maybe some folks had lunch hour. I want to thank Director Allen for this and for her generous thing that she will provide the slide deck. So we will have the slide deck. Of course, this session has been recorded. The slide deck will be available on our training resource tab. So you'll be able to pull it up there, as well as a link to the YouTube channel where your fellow commissioners who may have missed this can go ahead and review the actual recording. So without any further ado, on behalf of the OANC, I just want to thank you all for attending and look forward to our next training, which we will make you aware of in the next month. So thanks very much, everyone. Have a wonderful day. Enjoy the nice weather. I know it's cold out there, but at least it's not raining. So take care.
Thanks, everyone.